Anti-Semitism can manifest itself in different forms and shape and to various degrees. So to help state entities navigate when this type of discrimination is occurring, state lawmakers are looking to write a definition of anti-Semitism into the state's civil rights law and also encourage state agencies to utilize this definition when appropriate. For more on this effort, we're joined in the Capitol Press Room by Mark Goldfeder, a law professor at Touro Law School and CEO of the National Jewish Advocacy Center. Thanks for making the time, Mark.
Thank you for having me.
So for starters, why does it matter to have anti-Semitism defined in state law? I mean, are there other forms of discrimination that are explicitly spelled out the way that the policymakers are considering right now with anti-Semitism?
Well, here's the thing. When it comes to anti-Semitism, because Jewish identity is so multifaceted, right, encompassing aspects of race, nationality, ethnicity, culture, and religion, it is notoriously hard to define anti-Semitism. Jews are criticized for being whatever a society or a particular part of society hates at that particular moment. So at the exact same time, depending on what channel you're watching, you'll have people on the right calling them radicals and the left will label them fundamentalists. They're simultaneously too liberal or too conservative, too rich or a drain on society, too strong, too weak, too influential, too parasitical. So a definition of anti-Semitism has to be able to encompass all these possibilities and more. You have to be able to cut through all of the timely rationales that are given for this timeless hatred, because if you don't, anti-Semites will just find another rationale and use that one and then another and then another. So if you actually want to protect people, practically, you need a definition that focuses not on the reasons why people hate, but on the actions taken by those expressing or harboring hate. So it's like racism and sexism and other forms of bigotry in some ways, but it's different because of this multifaceted aspect, which is why you need a praxeological or a conduct-based definition, if you will, from a legal perspective.
I imagine, though, that there are black people in America who would say that their experience with racism is just as complicated. You could be not black enough, you could be too black, you could be a mixed race, and at least I'm not aware of racism being spelled out in that way. So is there any sort of precedent for something like this in state or federal law here in America?
Sure. First of all, if you remember, especially right after the George Floyd protests, there actually were tremendous amounts of lists given at universities, et cetera. But our black organizations said, no, you don't understand systemic racism. And here are a list of the things that we feel are racist that people are not understanding. So
but none of it was codified, though.
At the university level, a lot of it was codified. Yeah.
Doesn't codify mean right into law?
Or regulation.
Okay.
So again, at the university level, a lot of universities did write that into their codes of conduct, et cetera. So it was codified in that sense. But in terms of the codification in federal law, yeah, the IRA definition, again, it's in use now by over 30 countries and over 1,200 institutions worldwide. There are very few things that the Bush, Obama, Trump, and Biden administrations agreed on. This was one of them, right? And the reason, again, is at the end of the day, there can be no one exhaustive definition of anti-Semitism, right? It can and does take many forms. But in the 20 years that it's been in use, it has actually provided an objective baseline standard for what is and is not acceptable. And it has proven track record to be an essential tool for identifying the contemporary manifestations of anti-Jewish hate. So it has been adopted by many, many different governments, including our own federal government, including the majority of the United States. It's been endorsed by a growing number of world leaders, including the UN Secretary General, and many others.
So the pending legislation would utilize, as we've referenced, this definition of anti-Semitism developed by the International Holocaust Remembrance Alliance. And we can get into the proposal in a second, but I want to start with whether the alliance is the right entity to steer state policy. Because as you talked about, there are people and institutions that have endorsed it, but then there are also civil society organizations, here the American Civil Liberties Unions, that have raised question about whether the alliance is the right organization to be steering this type of policy, given that they've been criticized for deviating from maybe its core mission to provide what some might call political cover for the country of Israel. So given that backdrop, why are they the right entity to come up with the definition used by New York? Why shouldn't maybe the state convene a task force, a blue ribbon commission, come up with a definition that works, here in New York and is unique to New York maybe?
Sure. I never heard the criticism that IRA has anything to do with Israel. That's a new one for me. But
well, if you Google them for 5 seconds, you can find a pretty good track record of that type of
people
language.
Say that the IRA definition is used as cover for Israel because 7 of the 11 examples have to do with mention the state of Israel. Let me take a step back.
Sure.
The International Holocaust Remembrance Alliance, it's an intergovernmental organization. It's focused generally on Holocaust education and research and remembrance. But in the early 2000s already, with anti-Semitism once again on the rise, the experts at IRA on the Holocaust resolved to take a leading role in fighting it because never again has to start with early detection. And they realized you can't fight what you can't define. So they developed a working definition. And again, it was formally accepted by the then 31 countries in the IRA in 2016 as a way of early detection for, God forbid, another Holocaust. And since that time, as we mentioned, over 1,200 other separate governments, NGOs, and key institutions, etc. Now, some of the pushback that you get is that we mentioned that you need a praxeological or a conduct-based definition of anti-Semitism. The way that anti-Semitism works is that it oftentimes looks at Jews as a collective, right? Which is why the majority of anti-Semitism in any given era tends to focus on the primary form of collective Jewish identity at that point in history. Rabbi Lord Jonathan Sacks used to explain it, as throughout the Middle Ages, Jews were for the most part a religious community, so they're hated for their religion, even if the particular Jews who were being hated weren't religious. In the 19th and 20th centuries, a lot of Jews became secularized, so the primary unifying collective identity of Jews was their ethnicity. So the hatred focuses on race, and you end up with the Nazi Nuremberg laws, even a trace amount of Jewish blood. Today, when the primary collective embodiment of Jewish people on the world stage is the people of Israel and the Jewish state, Jews around the world are hated and they're held accountable for, quote, their country, even if they're not Israeli. That's why the IRA definition includes several very helpful examples of discriminatory anti-Zionism that can sometimes cross the line into anti-Semitism. So that's where the pushback comes from. But it's not about protecting Israel. It's about protecting innocent Jews who are often attacked because of a real or a perceived connection to the state of Israel. And to be clear, the IRA is not influencing American policy. The IRA has no binding force until an American legislature, like the legislatures in 38 other states, like the federal government, says this seems to be the correct version and we are adopting it. It has no force until it's adopted by the American legislatures.
Well, let's turn to the definition that's being considered here. Can you walk us through some of the examples? Because this is, right, not just a broad set of ideas. These are sort of specific ways in which something might fall under the label of anti-Semitism.
Sure. But I also want to make something clear. The reason why IRA is great is because the definition itself actually includes multiple guardrails. First of all, it says all of the examples given, including the ones about Israel, could, taking into account the overall context, be considered anti-Semitic. They're not automatically anti-Semitic. They are contextual, rebuttable evidence for an authority to consider when there's an allegation that a person was chosen to be attacked because of a protected aspect of their identity. And it is also important that all of the bills adopting the IRA definition only adopt it to protect against unlawful action, not speech. Protected speech remains protected speech until it becomes part of actionable discrimination, harassment, exclusion, threats, retaliation, unequal treatment, etc. So there's no censorship involved in those laws as well. Again, among the examples that Peter talked about are holding Jews collectively accountable for actions of the state of Israel. And if the bill is so narrow as I'm describing, why is it so important? Let me give you an example, if we have time,
Sure.
from New York itself. Okay, so just a few years ago, Saddam Massoud Saddam Massoud was on trial in federal court in New York on anti-Semitic hate crime charges on 3 separate occasions. Massoud and his accomplices violently assaulted 3 different innocent, visibly Jewish men, one of whom they sent to the hospital. And in court, Massoud's attorneys actually had the audacity to argue that he didn't target these innocent American, visibly Jewish people because he's an anti-Semite. No, he was seeking to, and I quote here, promote social and political goals. They said he shouldn't have used violence, but he just cared so deeply about Palestine that he lost himself in the moment and attacked innocent Jews. And incredibly, because there is currently no federal definition of anti-Semitism that prosecutors can point to, right? The State Department uses it, a lot of Title VI agencies uses it, but there's no criminal definition when you're assessing the intent behind discriminatory action. This was not speech, right? Or hate crimes even. That excuse might have worked, right? It has worked in other places. So right around the same time, there was a case in San Francisco where a man walked into a Chabad synagogue where a group of elderly Jews were learning Torah and started firing at them. And by the way, when they checked this guy's Facebook, He had pictures of himself dressed as a Nazi. He had a picture in house of that synagogue on fire. Anyway, the judge in that case said she didn't see any signs of anti-Semitic bias. But this time, thank God, in Massoud's case in New York, there was evidence, right? See, the prosecutors managed to get his signal messages, which he thought were encoded, and they showed the court his group messages where he said he conspired in advance to commit the attacks on Jews. And he warned his friends, remember, don't say Jew, say Zionist, so that my lawyer can get us off. He was literally trying to preserve this very argument. By the way, he wasn't the brightest, and I think it was victim three. He actually said, "Are you a blank Jew?" before he punched him in the face. But anyway, once those messages were out, the defense pulled the non-guilty plea, and Massoud went to prison. But the question remains, what if he had been smart enough not to put his hatred for Jews in writing? What would have happened? Could he have blamed it and said, I just cared about Israel and it was just political what I was doing? Wasn't actually a hate crime? That's the danger, and that's sort of the hole that the IRA definition bill is trying to plug.
You mentioned the idea of context and how that's an important factor when looking at these potential definitions. Is there, at least from your perspective, a rational way of looking at some of these things? Do you have faith in judges to take into consideration the appropriate context? I mean, you mentioned the example in San Francisco. I imagine you don't have a lot of faith in the judge in that case. So do you think that people will take a rational and reasonable approach to implementing these definitions if they are adopted into state law?
I do. And again, the 20 or so years of IRA's use has shown that when you give people an objective standard to look at, they tend to look at it. Look, and any context is crucial in any kind of anti-discrimination law, right? Normally, prosecutors look at a list of things. Among that list are prior statements, Facebook posts, writings, etc. All the bill does is it says, hey, you may not be aware of how anti-Semitism manifests today. Take a look at this one as well. Look, a recent study found that almost half of adult Americans don't know what the word anti-Semitism means. And those are the ones who were honest enough to answer the question. So charitably speaking, this just gives prosecutors a tool to be able to understand how it manifests. And less charitably, for those who are not inclined to ever see anti-Semitism, it's an objective requirement for them to at least consider it. And again, to the extent that they completely don't consider it and completely ignore it, it's something that the other side can go back to and point at.
And because this legislation, though, specifically references Israel, for example, are you concerned at all, or should people be concerned at all, that this is going to, say, stifle free speech regarding Israel? I mean, you brought up the idea that conduct of physical violence is clearly not speech, but are you concerned at all, or should people be concerned about this stifling a free debate about Israel and its policies?
Not even remotely. The bill simply cannot be triggered unless there is unlawful conduct. Let me give you an example. It's easier sometimes if we change the names. If I attack a Chinese person because I don't like our trade policies with China, right? That's national origin discrimination. If I attack a Russian person because I think Putin shouldn't have invaded Ukraine, right? That's at the very least national origin discrimination, if not racial discrimination. It's certainly ethnic discrimination, right? If I attack a Jew because I don't like Israel or because I don't like Netanyahu, that's anti-Semitism. It's the exact same thing. Somehow, for some reason, people don't see it that way. And they think, no, well, that's just political. It's not. And all the bill does is clarify this has never been about Jewish exceptionalism. It's only about Jewish equality. And somehow this exception got built into the system that when it's Israel, you can just say politics. It's not true.
Well, we've been speaking with Mark Goldfeder. He's the CEO of the National Jewish Advocacy Center and a law professor at Touro Law School. Mark, thanks so much for making the time.
Thanks for having me.
Support for the Capitol Press Room comes from O'Donnell and Associates, a public affairs firm providing strategic guidance to businesses and nonprofits on navigating policy and regulatory issues. More information is available at o'donnellsolutions.com.